This is LXBN TV, and I'm Colin O'Keefe. In Bland v. Roberts, the Federal District Court for the Eastern District of Virginia held that simply liking a Facebook page is not protected speech under the First Amendment. To explain the case, we bring in Debbie Rosenbaum, attorney with Morrison Foerster's San Francisco office and author on their blog, Socially Aware, which covers all things social media and the law. Debbie, first off, what's the context here? How did this issue come about?
Absolutely. So the case and the facts for our purpose here are the following. B.J. Roberts was up for re-election as a sheriff in a city in Virginia. When he was re-elected, 5 employees who had been part of his former administration were let go and subsequently not asked to be part of his new administration once he was re-elected. The 5 employees sued Roberts, alleging that their First Amendment rights had been violated when they argue for supporting the opposing candidate in that election. For specifically, two of the employees alleged that they had done nothing but merely like on Facebook the opposing candidate's page. So the court comes and looks at this and questions whether or not liking a page on Facebook is First Amendment speech and should it be protected under the First Amendment. And the court ruled that liking something on Facebook did not amount to constitutionally protected speech.
That's very interesting. We've seen, the First Amendment applies to so many different things that, of course, aren't just speech. Just last week I saw that it applied to blinking your lights at a passing car if they're speeding. The First Amendment applied to that. So why doesn't this constitute protected speech here in this case?
So the court argues that the liking a page on Facebook doesn't amount to constitutionally protected speech for two different but very interrelated reasons. The first is that the liking itself involves no actual words, the court writes. The second related reason is that the court writes that a mere clicking of a button is not the sort of constitutionally protected speech that was envisioned for First Amendment protection. And in the past, looking at other social media cases, this sort of expression did not kind of amount to speech that would qualify for First Amendment protection. What's interesting here, though, is that critics come at this decision from two different angles. The first is that, to your point, we have a slew of First Amendment law where non-speech is considered constitutionally protected speech. Burning of flags, wearing armbands, campaign finance. Mm-hmm. There are plenty of other ways to be expressive. And what the court writes here is that the mere click of a button should not warrant the protection of First Amendment speech. That remains to be seen, but that's what the court writes. The second reason why they argue or that critics come at this decision is actually kind of a nuanced technology reason. Mm-hmm. And internet law experts such as Eric Goldman point out that the mere liking of a page on Facebook isn't just an expression of an individual's support. It actually has algorithmic effects such as prevalence of publicity and visibility among interrelated networks. And so while these two things combined may not bring the liking of a Facebook page to warrant constitutionally protected speech, critics point out that at least it should be considered in the opinion.
Yeah, it's very interesting. I found that last point to be one of the most interesting critiques of it, because if you like a page, it appears on your friends' things, it's all over the place. It does more than just add your name to a list. I think that's what it seems like the ruling in this kind of indicates. But lastly here, how do you see this standard being applied to other social media activities, say a retweet on Twitter or even pinning something on Pinterest?
Yeah, so this holding will be really interesting to see how it's applied and to see if and how an appeal court considers the standard here, because the standard here was no actual words and a mere click of a button. So if we think about those, that means that if I pin a picture on Pinterest, or I repin a picture on Pinterest, that wouldn't necessarily qualify for First Amendment protection. But if I added a caption or repinned an image with actual content or words, all of a sudden that meets the threshold for constitutionally protected speech. Same thing with a retweet. So if a retweet, so a tweet is 140 characters, and that's one thing. But if I retweet somebody else's comment, that is nothing, that includes actual words and content, but it also is nothing more than a mere click of a button. So it'll be really interesting to see how courts delve into this standard and if this will be sufficient to withhold First Amendment doctrine in the world of social media and new media.
Yeah, it's going to be interesting to watch. So much I like to think of social media as just being the same things people have always done, but moving it online. But when you get into the intricacies of it, especially in First Amendment law, it becomes much, much, much more complex than just taking a normal activity and moving it online. So it's going to be interesting to watch going forward.
Absolutely. And also the technology component is a really interesting piece that will force judges and courts to delve into search engine optimization and algorithmic implications that I suspect they had no idea they were going to actually need to learn for the purpose of First Amendment law.
Yeah, it's going to be interesting to watch. Well, once again, that was Debbie Rosenbaum of Morrison Foerster and their Socially Aware blog. For more on this story and other commentary on the intersection of social media and the law, be sure to check out their publication. It's at sociallyawareblog.com. It's excellent. And of course, we cover this topic extensively as well at lxbn.lexblog.com. Thanks, Debbie.
Thanks so much.